Well, we have a guest joining us now here in New York. Larry Schoenbach is a criminal defense attorney. Thanks so much for joining us, Larry.
My pleasure, Lisa. Good morning.
Good morning. You know what? If I'm on the jury, I'm hopping mad when I go back into that jury room because this is a guy who lied. All right, we know to a certainty that he lied. His semen is on her body. He never explains that on the tape. Now, either he was, wasted out of his mind and he doesn't remember what he did in that room, which does not help him, or let's be honest, he had some kind of sexual interaction with her. He didn't just go in there and grab a purse. I'm going in mad. Now, maybe during deliberations, I'm going to be convinced that the proof that he's a killer is not there beyond a reasonable doubt. But what do you say as a defense attorney in closing arguments to address a juror like me who's already real angry at this guy?
Well, I think that's a problem because there is no explanation for his DNA anywhere in that room. It's not as if it's a fingerprint. It's not as if it's a skin cell. This is a very specific DNA, and without an explanation, the only reasonable one that jurors can draw is an adverse one against the defendant. I think
But does that make him a killer?
It makes him a liar, and it makes him at least an attempted rapist, perhaps. I think it's with a pillow over this woman's head. It's a very uphill road for the defense to go. Normally, well, let me say this. It's very easy for me to be the Monday morning quarterback.
That's our job.
But I was surprised to hear the defense attorney say that his client would testify in opening statements. Why close yourself off to an avenue?
I'm always amazed when they say that. I'm always amazed when they make that kind of promise because half the time they change their mind. It happens in a lot of cases. It happened in this case. But Larry, aren't you going to argue on the defense side she's got no defensive wounds? If you're going to asphyxiate someone, you're going to put a pillow over somebody's head and kill them. I'm sorry to say I know this, but from being at Court TV long enough, I do know it takes several minutes, 2 to 3 minutes minimum. This is a strong, healthy, athletic young woman. She's going to fight. She doesn't have any defensive wounds on her. Aren't you going to argue that?
Absolutely. The absence of evidence here is the best defense. It's the absence of skin or scratch marks, skin under this woman's fingernails, or scratch marks, apparently, or blood anywhere else in the room or on the victim.
Yeah, but what did you just say?
Probably.
Probably. You've got to erase all the reasonable doubt.
I can erase heart attack. You don't die of a heart attack with a pillow over your face and in that condition on the floor. I'm sorry.
Larry Schoenbach, is there any would you, as a defense attorney here, be specific and say, you know what, it could have been a heart attack, or do you just leave it, well, they couldn't tell us what it was their burden to prove it?
No, this is definitely a prove-it case, and you want as much doubt as possible. I don't want to call an expert unless he's going to come in and make a lock-solid statement, and I don't think any medical expert will do that. I would much rather, as a defense lawyer, argue the absence of proof, argue the absence of certainty in the medical examiner, whether it was asphyxia or strangulation or not, or smothering. But Lisa, I disagree with you about one thing. This woman may have actually died of a heart attack, but that's not the issue. The issue is, was the heart attack, if that's what in fact she died of, caused by this defendant? Right. So I'm surprised, frankly, that there is no connection there, or at least no attempt at connection by the state. But I'm also surprised that the state didn't charge a felony murder. Because,
yeah, go ahead and explain that.
Well, felony murder is no different than intentional murder, meaning the penalties are the same. The difference is the law itself. If you commit a felony, and in the course of committing that felony, someone dies as a proximate result of the felony, you are guilty of murder, as no different as well as if you had intentioned to do that. So that if you commit a burglary, and there's no question here that a burglary was committed because the defendant, Orange Taylor, admits to committing the burglary, and the woman dies as a result, she has a heart attack, she's frankly maybe scared to death, and I mean literally scared to death.
Well, that could explain why there's a lack of defensive wounds on her. Maybe it didn't take as long as it would take with somebody with a healthier heart.
Right. I mean, look, I'm a defense lawyer, and I'm trying to, figure out where to go with this.
You're also a dad, Larry, are you?
But I'm also a dad, and I have 3 daughters.
I can see that in you as you talk about this case.
Absolutely, and this one's troubling. And I give great credit to the defense lawyer to do what he can. But this is a very, very difficult case.
Larry, in terms of defending someone who's been accused of a crime, you know what all the evidence is going in. You kind of know what your witnesses are going to say. How much of a defense strategy evolves during the course of a case? Because here, it seems like they've done a 180 on the way they're going to present their case.
Well, in fact, the defense strategy evolves throughout the case. You never know what the testimony is going to be. You can read it beforehand, you can see the exhibits, but you never know how it's going to come out until it comes out. And that's why I had suggested earlier to Lisa that I was surprised that the defense attorney had announced to the jury in opening statements that his client would testify, because you never know if your client needs to testify or not.
But the prosecutor can't comment on that now in closing argument, right?
Absolutely. Not only can he not comment on that, there is an instruction by the judge that the jury is to not consider it whatsoever. You're not allowed to consider, as a juror, the fact that a defendant elects not to testify. The problem is the toothpaste is already out of the tube. The defense lawyer said, my client's going to take the stand and tell you what happened, and now he's not.
Can he argue that he sort of did through that police interview, the tapes that we heard for
Absolutely.
hour after hour after hour?
And that's exactly what he's going to say.
Hey, Larry Schoenbach, would you agree? Because it seemed to work for Phil Spector out in California, is an engineer type on that jury who might look at some of this evidence and say, you know, scientifically they didn't really prove it to me, you know, one way or the other. I could see both sides of this.
Well, there are clearly both sides. There is an argument here for the defense. It's an uphill struggle, but certainly an uphill struggle on what I'll call the lesser charges, the burglary, the sexual assault. The key here is the murder, and whether in fact it is a murder. The science doesn't exist. When I say it doesn't exist, meaning it's not present. This ME can't say what the cause of death is with medical certainty. And when I said earlier that when you're a defense lawyer, you're looking for the absence of evidence, this is where the absence of evidence exists. It's
well,
the
wait a second.
ME.
Can I jump in to defend the ME for
Sure.
a second? Because isn't it a valid scientific approach to say, I've ruled out everything else, and asphyxiation is what's left, therefore it's the only possible explanation?
And that's a fair comment. However, when you look at an autopsy report, and unfortunately I've looked at many in my career, there are specific indicia of asphyxia. For example, he talks about the injury on this woman's neck. It's clearly topical, assuming that you even concede that it's an injury. It's topical, it's even superficial, but it's clearly not a cause of death.
Okay, so he didn't use his hands to strangle her around
Correct.
the neck. He used
And
a pillow over her face.
Well,
probably the pillow that was found on top of her face.
Well, but let me finish. There is no injury apparently to the trachea, so there can't be any strangulation. Now, if it's asphyxia, which means simply that the pillow was over this woman's face and she suffocates to death, there is an indication, there's a biological indication of that, and that's usually found in the eyes. And what happens when you suffocate to death, the small blood vessels in your eyes burst. And I'm sorry to be graphic.
No, it's okay.
But this is the absence of evidence. This is where, yes, you're absolutely right, Lisa. The ME can say, look, I've looked at everything else and there's nothing else, so it has to be this. But there is no medical science to prove this. So the absence of evidence here, specifically the absence of the burst blood vessels, that's not, decomposition, because he said one eye was in fact intact. There would be an indication of asphyxia, and it doesn't exist here. But by the same token, there would be indication of a heart attack.
Right.
Right, so it's
And there's
just
nothing there. Those are reasons for doubt. And that's exactly what a defense lawyer does.
Larry Schoenbach is still with us here in New York. Larry, how do you think it's going for the defense in these arguments and discussions about what exactly this jury should be charged with?
Well, I think it's going as expected, which is not well. The judge is absolutely correct on the instruction concerning the felony murder. And I'm frankly, as a defense lawyer, I'm disappointed to hear that there was a felony murder charge. As a citizen, I'm very happy that there's a felony murder charge.
You think that's the strongest argument, don't you?
Oh, absolutely. Absolutely. Because the defendant concedes the felony. He doesn't concede necessarily the sexual assault, but he concedes the burglary, the home invasion. With that, everything else is much ado about nothing. But the judge is absolutely right. The law doesn't require a conviction for the underlying felony as a predicate to the felony murder. It does require proof, and proof beyond a reasonable doubt. But the people are well within their rights whether to charge it or not, so long as they charge felony murder and so long as the felony murder is, the underlying felony is proved. This is not going well for the defense.
Yeah. And it absolutely is proved. There's no doubt. I mean, he admits it in the tape. We've seen the videotapes of him coming into there. We've heard the audio tapes of him talking about it. So that's a big problem for the defense.
You know, Larry, I'm interested when you say that as a defense attorney you don't like it, but as a citizen you do like it. Do you ever get concerned about that conflict?
No. In a word, no. I mean, I know most people don't understand this, but defense lawyers are actually people, and we have feelings.
I think
sometimes pinky rings.
I think
Not
some
me.
people do.
I go to line of pinky rings. But no, this is like being pregnant. When you're a defense lawyer, you either can do it, and you do it 1,000%, or you can't do it at all. You can't make that distinction, because once the door closes behind you in the courtroom, you must give your all to the client, whether you like the client, whether you like the case,
And
whether
we
you like
like
the
you,
facts.
and we like defense lawyers.